Acting Deputy Chief Justice, with your leave, can I ask the Registrar Clerk to call the case, please?
Yes, you may, my sister.
Good morning. I am the Registrar Clerk for this hearing. Acting Deputy Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of David Kgabagare Langa and Premier Limpopo Province and others for hearing. Counsel are invited to place themselves on record. Please note that this hearing is being recorded.
Thank you,
May
Mr.
it please you, Acting Deputy Chief Justice and other justices, I appear for the appellant together with Advocate Laimi and Advocate Matlapi.
Thank you, Mr. Da Silva. Mr. Becker.
Good morning, Justices. It's Becker, SC, from the Johannesburg Bar. I'm appearing in this matter on behalf of the respondent in this matter, and I'm assisted by Professor Letswalo.
Thank you, Mr. Becker. Mr. Da Silva, the ball is in your court.
May it please you, Acting Deputy Chief Justice, if I can refer the Honourable Court to the appellant's heads of argument, and specifically, I do not intend repeating everything that's said in the heads, and I'll just briefly refer to certain aspects which I submit are important in our heads of argument. If I could take the Honourable Court to page 3, paragraph 2.2, we submit that this matter deals, or the issue in this matter deals with two interrelated decisions of the first respondent concerning the removal of the appellant as senior traditional leader of the Mapela traditional community and the recognition of the fifth respondent as senior traditional leader. Both decisions were effective on 1 April 2017. Then if I can move over the page to paragraph 2.6, one notes that the decisions were taken on 1 April 2017. If one looks at the record, volume 1, page 36, one sees the decision was signed by the Premier at the bottom of the page on the 1st of April 2017, and one sees that he approved that the appellant be relieved of his duties as the senior traditional leader of the Mapela traditional community in terms of section 13 of the Limpopo Traditional Leadership and Institutions Act, and then 2, that Langa Hans Malesela be recognized as the senior traditional leader of the Mapela traditional community in terms of section 12(1)(b) of the Limpopo Traditional Leadership Act. I'll refer to that act as the Limpopo Act. We submit in paragraph 2.7 of our heads that the matter raises the following constitutional issues. 1, it concerns the institution of the tradition leadership and the determination of who should be appointed in the position of traditional leadership. 2, it involves the non-compliance with various provisions of the Limpopo Act, and this has an effect on the principle of legality. 3, it involves the right to lawful, reasonable, and procedurally fair administrative action. 4, it deals with the admissibility of the contents of the reports of the commissions into evidence. And then lastly, it deals with the right to a fair hearing in terms of section 34 of the Constitution. We submit further in paragraph 2.8 that it is in the interest of justice that leave to appeal should be granted if the following is considered. The issue whether the Premier should have complied with section 3 of PAJA before he made the decision. The matter involves the proper interpretation and application of the Framework Act and the Limpopo Act. And we submit that the disputes pertaining to traditional leadership be resolved with certainty and clarity in order to maintain stability. It affects various communities in South Africa. And then lastly, we submit that there's a reasonable prospect of success considering the merits of the matter as further demonstrated in our heads of argument. In paragraph 3, we set out the background and chronology of the events leading up to the decision on 1 April 2017 and these subsequent events. I did not intend going through the whole chronology. What is important, I submit, what's not contained in the chronology is when the appellant was informed of the decision. He was informed on the 8th of December 2016, and one finds the letter in volume 1 at page 39. One sees at page 39, volume 1, that the appellant was informed by the committee on the 5th of December 2016, kindly be informed that the claim for the restoration and recognition of the lineage of Alfred Sidebu Langa by Mr. Langa Madimetse Joseph is accepted. That's the first time he is informed of this decision. That's 2016, and one takes into account that the commission actually started sitting on the 14th of February 2013 and made its recommendations on the 17th of September 2013. There's no explanation why there has been a delay for more than 3 years before the appellant was informed of the decision. So, informed of the recommendation by the committee. As regard to volume 1, and one goes over the page to page 40, the appellant's erstwhile attorneys wrote a letter on the 20th of January where they requested a copy of the findings of the commission. And if one turns further in volume 1 to page 42, the reply is contained at page 42, paragraph 2. The committee adopted the attitude that the report can be accessed through the Promotion of Access to Information Act. And the appellant, if one has regard to volume 1, to date has never received a full report of containing all the annexures of the report by the Kgabagare Commission, the 4th respondent. If I may take the Honourable Court then to our heads, page 11, paragraph 3.9.4, we make the submission that there's no evidence that the report of the 4th respondent was received by the Premier, the 1st respondent, and that he applied his mind to it in order to act further as prescribed by Section 30 of the Limpopo Act. The 1st, 2nd, 3rd, and 4th respondents concede that Section 30 was not complied with. So it's common cause that Section 30 was never complied with. We note from the decisions or the records, as far as the resolutions that were considered by the royal family, the Mapela royal family, we see, if I may refer the Honourable Court to page 12, paragraph 3.9.6, that there was a meeting, there's an attendance register of the royal family on the 2nd of December 2016. All one has is an attendance register. There are no minutes, even though Section 17.2 of the Limpopo Act provides that the royal family should keep a minute book and minute all decisions together with the dates on when the decision was taken. So one knows there was a meeting on the 2nd of December, and one does not know what was discussed at this meeting of the royal family. The same applies to a meeting which took place on the 5th of December 2016. There's just an attendance register. And then, if I may take the Honourable Court to paragraph 3.9.9, on the 6th of December, there is a meeting noted, and what the royal family notes is, we do hereby acknowledge the appointment of Hans Malasela Langa as the chief of the Langa tribe of Mapela, as he is the legitimate one to hold the title of Hans Maseba II. What is interesting, if one goes through the papers, including the notices that were published by the Premier, is that the person that's appointed is Hans Malasela Langa, but the fifth respondent is Mr. Hans Maseba Langa. The names differ, and there's no explanation how this came about. One notes, if I can take the Honourable Court to paragraph 3.9.12 of our heads, the Premier approved the recommendations of the MEC on the 1st of April. I've already alluded to that. One finds the approval by the first respondent at page 36 of volume 1. If I may then take the Honourable Court to our submissions, the first aspect, if I may refer the Honourable Court to page 17 of our heads of argument, paragraph 4, where we deal with section 13 of the Limpopo Act. Now, what is important, if one looks at the recommendations made by the Kgabagare Commission of Inquiry, the recommendations appear at page 18 of volume 1. And if one reads page 18, it's paragraph 9, it reads, the Commission recommends that, and then 7.1, the lineage of the late Hendrik Madikwe Langa as a ruling lineage be terminated, and that the current incumbent, Kgabagare David Langa, who is the appellant, be removed from his position in terms of the provisions of section 12(1)(c) of the Traditional Leadership Governance Framework Act, read with section 13(1)(c) of the Limpopo Traditional Leadership and Institution Act. So it's quite clear what the basis on which the appellant was removed was in terms of 13(1)(c). One knows.
Mr. Da Silva, if I may interrupt just to indicate that your protection time has expired.
Certainly.
You may take questions from the bench.
May it please you, Acting Chief Justice Kampepe. So the submission we make is that it's quite clear that the basis on which the appellant was relieved of his duties was in terms of section 13(1)(c), was a wrongful appointment or recognition. That's the basis, and that's what the recommendation is. It couldn't have been on any other basis. If one studies the provisions of Rule 13 of section 13(1), there are 5 bases on which a removal could take place, and the other 4 do not apply. So only he was removed on the basis of 13(1)(c), which was a wrongful appointment and recognition. So if one turns to page 18 of our heads of argument, paragraph 4.6, we make the submission that section 13(2) only applies when any of the grounds referred to in subsection 1, A, B, C, A, B, D, and E are applicable, and it comes to the attention of the royal family. The point I wish to emphasize is that 13(1)C is not applicable. So,
Mr. Da Silva, can we clear one thing first? We're not here to look into the validity of the commission's determination as to who should be the rightful traditional leader. Is that correct?
Justice Jafta, I know my learned friends advance that argument, and you'll note that the brunt of our argument deals with the provisions of the Limpopo Act and the Framework Act. But I want to state that we did not abandon the, or the appellant has not abandoned the review of the Kgabagare Commission of Inquiry. I know there's a wording in the affidavit which is a bit problematic, but my submission to this honorable court is that the appellant never abandoned his rights to review the decision of the Kgabagare Commission.
Well, at the beginning of your argument, you took us to the two decisions which you said your client is pursuing the attack on. And those are the decisions of the Premier. One
Yes.
is the decision to withdraw the certificate of recognition of the applicant as the traditional leader. Two, the certificate, the decision to implement the Commission's decision without following or complying with Section 30 of the Limpopo Act. So I just wanted to know that we should concentrate on those. The validity of the determination by the Commission is not an issue before us. Well, if the applicant wants to pursue that, he may pursue it at another stage. But before us, the focus is on decisions made by the Premier. One, withdrawal decision. Two, recognition decision without complying with the Limpopo Act. Is that correct?
Justice Jafta, you are correct. The only point that I wish to make is, and you'll see in our argument, we focus on those two decisions.
Yes.
The point that I also wish to make is that the appellant never abandoned the right to review the Kgabagare decision, the Kgabagare Commission's recommendations with respect.
Yes, then I understand that. But I wanted just to clarify where we are, the scope of the hearing. What are we looking at?
Yes.
All right.
No, you're correct. The main focus, Justice Jafta, is on the two decisions that were taken on the 1st of April.
Yeah. If that is so, what bearing does that have on your submission relating to Section 13 sub 2 of the Limpopo Act, which leaves out of the list the ground in Section 1C? Because as I understand it, this was not a process that commenced with the traditional or with the royal house removing a traditional leader in office on the basis that there was a wrong appointment. This was an enforcement or implementation of a decision by the commission, which is different. It has nothing to do with the royal family. Once the commission takes the decision, then the Act tells us the process that should be followed in the implementation of that decision, and that is where Section 30 of the Limpopo Act comes in. Am I wrong?
Justice Gafta, I think the first point in attempting to answer your question is that one must bear in mind that there was an amendment to the Act in 2009, which became effective on the 21st of January 2010, where the committee no longer made decisions, but made recommendations. So the committee makes a recommendation, and one gets the impression that from the record that the Premier exercises his powers in terms of Section 13, which he is not entitled to do. And that's our submission, that the principle of legality wasn't complied with.
I'm sorry. I don't know, there's an echo now. You took us to the decision/recommendation by the commission, and you pointed out the references to certain provisions of the Act.
Yes.
Now, in his or her decision, the Premier now, does he refer to those provisions, or does he refer to Section 30?
Justice Jafta, if one looks at the actual decision that the Premier takes,
Yes.
if one turns to page 34, I apologize, if one turns to page 36, if one turns to page 36, one sees that what the Premier approves is set out at page 36, and 6.1 says that Langa Kgabagare David be relieved of his duties as senior traditional leader of the Mapela traditional community in terms of Section 13. So he applies specifically Section 13. He doesn't apply Section 30. And it's common cause between the parties that Section 30 was never applied. So he purported to exercise his powers in terms of Section 13 of the Limpopo Act. And we submit, to cut to the chase, that he never had the power to act in terms of Section 13.
Yeah, I see your point. I'm sorry. I see your point, Mr. Da Silva, that the Premier seems to do what he is not empowered to do by Section 13. As I understand, Section 13 permits the Premier to withdraw the certificate of recognition. And here the Premier purports to remove your client from office.
Yes.
So
we submit, Justice Jafta, that what the Premier did is he purported to act in terms of Section 13, and more particularly Section 13(1)(c), without having the powers to do so.
And also, yes, would you finish, please?
Yes. And it's also common cause that he never acted in terms of Section 30. And there were certain rights that flow from the provisions of Section 30, which the Premier never exercised. So there are on various grounds we submit with respect that both the Limpopo Act and the Framework Act, the provisions of those two acts, weren't complied with.
And in 6.2 on the same page, he purports to have acted in terms of Section 12(1)(b) of the Limpopo Act in recognizing Mr. Hans Malisela Langa.
Yes.
When in fact he was required to implement the decision of the Commission in terms of Section 30 of the same Act.
Yes. Yeah. It's correct, Justice Jafta. He should have implemented the recommendation. But what is important about the point that you're making, Justice Jafta, in 6.2, where he recognizes the fifth respondent in terms of Section 12(1)(b), he can only do that with respect if there's a vacancy. Section 12(1)(b) specifically says, if one looks, or Section 12(1) specifically reads, if one reads, it says, whenever a position of a senior traditional leader, headman or headwoman is to be filled. So the first requisite is that there must be a vacancy. And there was no vacancy. The appellant was the incumbent. In fact, the appellant was appointed in 2009. And once he is appointed by the Premier is functus officio. He can't take any other decision. He's appointed the appellant as the senior traditional leader of the Mapela community. So he's never complied with the first requisite of Section 12. Section 12(1) says there must, when the position is to be filled, and then it has further requirements. The royal family must identify the person, and then to give reasons for the identification. And then the Premier must give a notice in the Gazette and issue a certificate. So we submit with respect that when the Premier purported to act in terms of Section 12, he was also exercising powers which he never had and which he was never entitled to exercise. With respect.
Let's go back to Section 13(2). I understand, yes, when one reads it, one sees that the ground in subsection 1(c) is left out.
Yes.
Now, when one goes to subsection 3, it refers back to subsection 2.
Yes.
And allows or permits or mandates the Premier to exercise power where there would have been a removal of a traditional leader in terms of subsection 2.
Yes, and subsection 2, sorry, I'm interrupting. I apologize, Justice.
Now, we know that subsection 2 leaves out of account the ground in subsection 1(c). So, which suggests then that the royal family can only remove a traditional leader in terms of subsection 2 in respect of only those grounds that are listed.
Yes, you're perfectly correct.
Now the question must come as to who, according or on whom, according to the Limpopo Act, is the power to remove on the ground in subsection 1C is conferred. Who would, if the royal family cannot remove a traditional leader under that ground because it is left out of those listed in subsection 2, who under the Act would exercise the power to remove a traditional leader under the ground in 1C?
We submit with respect, Justice Jafta, that what section 13 envisages is that the process set out in section 13, the royal family has the powers as set out in section 13, but that does not preclude a royal family from removing a traditional leader in terms of 13(1)(c), except that if the royal family wants to remove a senior traditional leader in terms of 13(1)(c), it doesn't do so in terms of the procedure. The royal family goes to court. One of the avenues, there could be other avenues, but the most obvious avenue is that the royal family, as an interested party, would go to court and bring an application for reviewing the appointment or recognition of the senior traditional leader because of the wrongful appointment or recognition. That would be the avenue we submit that the royal family would follow in that type of case.
No, but section 13(1) sets out the grounds on which a sitting traditional leader may be removed from office.
Yes.
And from subsection 2, we know that grounds A, B, D, and E can be used by the royal family to remove a sitting traditional leader.
Yes.
Now, my question was, if we read this act properly, on whom would we say the power fall to remove a traditional leader under the ground of 1C?
I understand my learned junior wishes to say, would you bear with me? Okay. Yes. Yeah. If one reads section 13(1), it appears that a senior traditional leader will be removed on one of those 5 grounds. We submit with respect that the royal family would have the power to remove a senior traditional under 13(1)(c), but we submit it would not be in terms of the procedure set out in section 13. What the royal family would have to do is go to court and possibly bring a review application. And the further leg to our submission in an attempt to answer your question, Justice Jafta, is that certainly the Premier doesn't have the power to remove the senior traditional leader in terms of section 13, and particularly 13(1)(c).
Yes. Yes, now I get your argument, Mr. Da Silva. Even though it is strange to me that the power would sit in section 13 and the grounds are listed there, but when the royal family wants to exercise that power, they have to go to court. I'm not quite sure whether it is the court that now exercises the power in section 13, but I got your argument. Thank you.
Yes, the submission is that the Premier has appointed the senior tradition leader in terms of Section 12, and in terms of the in our heads of argument, in our list of authorities, we refer to the first authority, the Chivalana royal family decision, and that's a decision of this honorable court, where this aspect was discussed. If I recollect correctly, it's at paragraphs 41 and 42. And if one reads paragraphs 41 and 42 of that judgment, the learned justice said, the removal of a headman is governed by Section 12 of the Framework Act. In terms of Section 12, the royal family may request the Premier to remove a headman on the grounds listed in 12.1a, B, and D. The royal family, however, may, however, not request the removal of a headman on the grounds of a wrongful appointment or recognition. The Framework Act does not prescribe a procedure for removal of a headman on the grounds of a wrongful appointment or recognition. And then the learned justice says the following at paragraph 42. The Framework Act gives the Premier the exclusive power to recognize a headman. He or she does not have the power to remove a headman on the grounds of a wrongful appointment or recognition. The reason why the Premier is not reposed with this power must be because that would give rise to a conflict. It would be the appointment action that is impunged. All recognition disputes would therefore involve the Premier. The legislature recognizes by implication that the Premier may not revoke or review an earlier decision because he or she would be functus officio, having discharged his office or her office. And that's in essence what our submissions are in this regard. Yes, certainly.
Mr. De Silva, can I just ask, in the room where you are, are there two connections to the YouTube channel? Because I think that's where we're getting the echo from.
I apologize. I wasn't aware that there was an echo. I see that my learned friends' laptops, they under mute, so there shouldn't be an echo.
Okay.
We have a technician that's present, and I'll try and sort that out, Justice Theron.
Yes, thank you, Mr. De Silva. While they do that, Section 13, 1A, B, C, D, E, and F lists the grounds upon which a relief of royal duties can take place.
Yes.
But it doesn't give the authority to remove on those grounds. It merely lists that someone could be removed on those grounds. Would you agree with that?
I agree with your point. Yes, certainly, Justice Theron.
Yes, and as you've read from the case a minute ago, and as Justice Chapter has said as well, subsection 2, 3, and onwards does not make provision for the procedure to be followed when someone is being removed on the ground of wrongful appointment or recognition.
That's correct.
Yes. So isn't it so that there's no specific power in 13.1 to remove for wrongful appointment or recognition? There's no specific power given to any individual or body. You agree with that?
Yes. Section 13.1, as I understand it, Justice Theron, basically says what grounds the relief can take place. Yes.
Yes. Now, when the Premier is acting to remove a person on the grounds of wrongful appointment or recognition, the grounds come from Section 13.1, but the power is not sourced in that section. mustn't we then look to the Framework Act? Because the Framework Act says that the Premier must act on the recommendation of the Commission. So those sections have to be read together. So where the removal from the instructions or finding of the Commission is based on wrongful appointment or recognition, then the Premier is acting on the instructions or the decision of the Commission, but the ground is based on 13(1)(c).
If you'll bear with me, I seem to have, my Framework Act seems to have disappeared. I apologize. It appears if one looks at the Framework Act, Justice Theron, that the removal would be in terms of section 12. And the provisions are very similar to section 13 of the Limpopo Act in the sense that it sets out what the grounds are, except that there are only 4 grounds. And then if one looks at sub 2, once again, the wrongful appointment or recognition is left out.
Mr. De Silva, which section of the Framework Act are you looking at?
I'm looking at section 12, Justice Theron.
Of the Framework Act?
Yes, yes.
Yes, I would like you to look at section 30, please, Mr. De Silva.
Of the Limpopo Act, Justice Theron.
No, I'm sorry, section 26 of the Framework Act.
Yes, section 26 deals with the recommendations of a commission, yes.
Yes. Now, before we go into the recommendations, there is a problem. Under the, well, at least as I see it, under the 2003 Framework Act, it says a decision of the Commission must be conveyed to the President for immediate implementation. The 2009 Act calls it a recommendation.
Yes.
And in terms of the 2009 Act, 26 subsection 3, the President or the functionary, who we know to be the Premier, must make a decision within 60 days.
Yes.
Based on the decision of the recommendation.
Yes.
Subsection 4, if the Premier takes a different decision that differs with the recommendation, he must provide reasons for such decision.
That's correct. Yes.
Now, the Limpopo Act doesn't reflect the provisions of section 26 of the Framework Act. See, the Limpopo Act came into existence while the 2003 Act was in existence.
Yes.
Then the 2003 Act was amended in 2009 to give the Premier a discretion.
Yes.
And that's not reflected in the Limpopo Act.
Yes.
What are we to make of that?
Well, I submit with respect, first, the first starting point in interpreting these acts is set out in the Limpopo Act. If one turns to section 2, it deals with the interpretation and application of the act. And section 2 sub 1 says this act, in other words, the Limpopo Act, is subject to the Framework Act. So we submit that the Framework Act takes precedence over the Limpopo Act. But to answer your question, Justice Theron, if one looks at section 30 of the Limpopo Act, it reads, the Premier, 30 sub 1 says the Premier must, within 7 days of receipt of the decision of the Commission, in terms of section 26 sub 2 of the Framework Act, refer such decision to the Provincial House of Traditional Leaders for its advice on implementation. So we submit with respect, it's peremptory. The Premier must refer it for the advice on the implementation. And 2, the Provincial House of Traditional Leaders must submit its advice contemplated in subsection 1 to the Premier within 14 days, provided that the Premier can shorten the period. And then 3, the Premier must implement, it says the decision, but we submit as a result of the amendment, one should read that as a recommendation. The Premier must implement the recommendation of the Commission within 30 days of receipt of such decision from the Commission. So we submit with respect, one must read section 30 in conjunction with the Framework Act, but there's a certain procedure that has to be followed, because the Premier, before he wants to remove or wants to implement a recommendation of a committee, must get the advice on the Provincial House of Traditional Leaders. So there's a certain procedure that must be followed.
Mr. De Silva, section 30 sub 1, 2, and 3 of the Limpopo Act.
Yes.
Must they be read conjunctively? Is there and?
No, there is no and, but it's quite clear, we submit with respect, that it sets out a certain time frames that have to be complied with. So it's a consequential steps that have to be taken. So in other words, the Premier must within 7 days ask for advice from the Provincial House, and the Provincial House must provide the advice within 14 days, and then the Premier must implement within 30 days. So there are three.
Mr. De Silva, please look at sub 3. It says the Premier must implement the decision of the Commission within 30 days of receipt of such decision from the Commission.
Yes. Yes, yes.
It doesn't say anything about implementing within a certain period after receiving advice from the traditional house, from the Provincial House of Traditional Leaders. I would understand your argument if sub 3 said the Premier must, within a certain time after receiving the advice in terms of subsection 2, take certain action. Can section 30 sub 3 not be read as a standalone option for the Premier?
I submit not, with respect, Justice Peron. We submit that subsection 3 merely sets out a time frame within which the Premier must exercise or implement the decision. But we submit that on the interpretation that you suggest, with respect, Justice Theron, the intention of the legislature was not to negate the provisions of subsection 2. All that subsection 3 basically does, we submit, is it's not a standalone provision. Basically, all that subsection 3 directs is that the decision must be implemented within a certain time frame. That's all it says. But before one gets to subsection 3, subsection 2 must be complied, and one must take into account that both provisions use the word must. Both subsection 1 and subsection 2 use the word must. And we submit with respect that these provisions are peremptory. You will recall that my learned friends rely on the decision of Ludidi, and Ludidi was a decision.
Mr. De Silva, I'm sorry to interrupt you. Before you go to Ludidi, can we just finish this point on section 30?
Certainly.
If we accept your interpretation that the Premier must first refer the decision to the Provincial House, do you accept then that in this instance, the power of the Premier is sourced in section 30 based on him acting on the recommendation of the Commission, and the grounds for removal is sourced in section 13(1)(c)?
May I just discuss the matter with my learned junior, Justice Theron? Can I ask you to bear with me for just 4 minutes?
Yes, Mr. De Silva.
Justice Theron, my submission to you is that if one takes into account the Chibulani decision that I just read, the paragraphs 41 and 42, we submit with respect that the Premier's functus officio, he has already appointed the senior traditional leader, and he doesn't have powers to remove on an interpretation that you suggest with respect, Justice Theron.
But then, Mr. De Silva, I'm getting the echo again. That then renders section 31 redundant in many instances. If you say that the Premier cannot remove because he or she was the one who made the appointment. So is your argument that even on the recommendation of the Commission, the Premier does not have the authority to remove? I would say that that doesn't make sense somehow.
It appears, Justice Theron, that you are correct on the reading of section 30, but one must take into account, if one takes the decision that I referred to, it appears that that would be the procedure that you suggest that would be followed, is section 30, yes. Justice.
So the Premier would then, if there's a decision from the Commission to remove, be acting in terms of section 30 together with section 13(1)(c).
Yes.
Thank you, Mr. De Silva.
Just as a follow-up on this question, section 30, subsection 1, which you said is peremptory, he must refer for advice. Should the advice go to the substance of the recommendation, or is it limited to the implementation of the recommendation? can the House change the substance of that recommendation?
I would submit, Justice Tlaletsi, the advice. I see how you approach it, but I would submit that the advice could go to the substance of the recommendation. For example, if for some other reason the House of Traditional Leaders, they know that the decision is incorrect or the recommendation made by the committee is incorrect. An example.
But will that be amount to advice on implementation?
I would submit that it would include advice on the substance of the decision and implementation, because what the advice would be is, we advise you not to implement this decision because it's incorrect. And then they would be dealing with the substance of the recommendation. And the advice would be, because of the substance of the recommendation is incorrect, that the recommendation should not be implemented. That is our submission. An example, a possible example, if one takes the present case, one sees the recommendation by the Kgabagare Committee. One sees that at page 18. What they say at 7.2 is they say the lineage of the late Alfred Sidebo be restored, enhanced, Malesela Langa II be recognized. That's what they say. That's the recommendation. Now, if you turn to the genealogy, that's at page 19. And the genealogy, page 19, this is exactly what the quota quo approached the matter on. Now, if one looks at the genealogy, one sees that Alfred Sidebo belongs to the first house, but that the fifth respondent, in fact, belongs to the second house. So the recommendation that was made is that the first house be restored, but the fifth respondent doesn't come from the first house. So the House of Traditional Leaders could look at genealogy and come to the conclusion. The recommendation by the committee is that the House of Alfred Sidebo be appointed, but by implementing that, it would be incorrect to appoint the fifth respondent. And on that basis, they would advise the Premier and say, what you want to do now is not in accordance with the finding of the Commission. And what you want to do by appointing the fifth respondent is incorrect.
I hear you.
Mr. Silva? No, I'm sorry, my brother. Mr. De Silva, what you have said is to some extent oversimplifying it. Even though the fifth respondent comes from the second house, but I think we're going off the point for a minute.
Yes, yes.
Is that wasn't it established in terms of lineage? He was higher ranked than the applicant.
Yes, that is part of the reasoning. But the point I'm making, Justice Theron, is if one looks at the recommendation that the committee made and what in actual fact was being implemented, it's two different things. What the committee intended to recommend was to restore the first house. But the fifth respondent doesn't come from the first house. He comes from the second house.
Yes. I have two more questions, please, Mr. De Silva.
Certainly, Justice.
You refer to the case of Shivulana. What was said in that court about recognition? Weren't those comments arbiter? What that case was concerned about was exhausting internal remedies in terms of Section 21 of the Framework Act. That was the central determination in that court, in that case.
Justice Theron, I submit with respect, it's a decision I'm looking at the decision now. It's a decision of this honorable court. It's a decision by the Constitutional Court, the highest court in our country. And it's a unanimous decision by all 11 judges. There's no dissenting opinion in this decision. All 11 judges.
My question, Mr. De Silva, was that not obiter?
My answer to you, Justice Theron, is that even if it is obiter, it carries great persuasive power because it was 11 judges expressing an opinion on what the powers of the Premier were, that in fact he had appointed a senior traditional leader and he was functus officio.
I think we're going back because I think you did accept earlier that if the Premier acts in terms of Section 30 of the Limpopo Act, he has got the power to remove if that's on the decision or recommendation of the Commission. My second question, Mr. De Silva, if this court is minded to find that the Premier does have the authority to remove based on the decision or recommendation of the Commission, read with Section 30 of the Limpopo Act and Section 13(1), if the Premier did not refer the decision to the Provincial House of Traditional Leaders, what would your submissions be in terms of remedy?
We submit with respect that it would serve no purpose in remitting the matter to the Premier. And I would imagine that is in essence what you have in mind, Justice Theron. There are several factors that play a role. There's been a huge amount of time that has lapsed. The committee made its decision in September 2013, a recommendation in 2013. And this is 7 years down the line. A lot of water has passed under the bridge. And we submit that it would serve no purpose in remitting the matter back to the Premier. We submit that what this honorable court should do is find that the decision or the recommendation or the decision by the Premier was contrary to the Constitution, and we'd request you to set it aside. It does not mean that whoever is affected by the decision doesn't have further remedies. The fifth respondent has further remedies, and the royal family, if they wish to exercise their remedies, they have remedies at their disposal. So we request you, if you have regard to our heads of argument, we've set out the order we seek at page 49 at paragraph 8.2, Justice Theron. So we'd ask you for an order in terms of paragraph 8.2 of our heads of argument.
Perhaps I'll ask one more question, Mr. De Silva. Do you still rely on the procedural fairness point and that the applicant ought to have been afforded a hearing by the Premier?
Yes, we certainly do. And if you take the timeframes into account of what happened, for example, the fourth respondent makes its recommendation on the 17th of September 2013. And the appellant is only informed of the decision, recommendation, 3 years and 3 months later. We submit with respect that the procedural fairness provision should have applied to him.
Do we know why there was the 3-year delay?
No, from the papers, it doesn't appear. From the record, there's no explanation why there was a delay with respect. I'm not aware. There is on the papers, as I understand the papers, Justice Theron, there's no explanation for the delay.
Mr. De Silva, if my sister is finished, I'd like to just raise the Tsibolane case with you again. In Tsibolane, the court at paragraph 41 pertinently says the Framework Act does not prescribe a procedure for the removal of a headman. And that is what your argument is based upon. Now, if you read section 2 of the Limpopo Act, it says the Framework Act applies, this act must be read subject to the Framework Act, the Limpopo Act. And that is understandable. That's how I understand it. The National Act must take preference because it sets out the framework. But it does seem to me that this must be obeyed because we all know that the Framework Act does not have a procedure for the removal of a headman. And where the Framework Act is silent, it seems to me then that the Provincial Act, if it does have provisions dealing with that, must therefore apply. Otherwise, there will be a lacuna on removal. So it must be that the Limpopo Section 30 must apply, not so? If we accept that the National Act, the Framework Act is silent on the question.
If I understand it correctly, Justice Majid, the Framework Act, Section 26 makes provision for removal. If you'll bear with me. Section 26 of the Framework Act deals with the recommendations of a commission.
Yes.
And if one has regard, for example, to section 26(2), it says a recommendation of the commission must within 2 weeks of the recommendation having been made be conveyed to the president or the relevant government functionary. And then it reads, subsection 3 says the president or the other relevant functionary to whom the recommendations have been conveyed in terms of subsection 2 must within 60 days make a decision on the recommendation. So I would submit with respect, Justice Majid, that the provisions, although they aren't identical to section 30, there are similar provisions in section 26 on how the recommendations of a commission would be implemented, Justice Majid.
Well, if you read those two sections, 26(3) of the National Act and section 30 of the Limpopo Act, congruently, if you read them together, there's no conflict. And therefore, it means that it must be the authority concerned, i.e. the premier in this case, that takes that decision. Do you accept that?
Yes, I accept that, Justice Majid.
Yeah. Now that leads me to the second and the last question, which brings me back to the question that Brother Jafta asked you right in the beginning. And that is that, as I understand it, you have expressly abandoned the challenge. When I say you, I mean your client, of course. Mr. Langa had expressly abandoned his challenge against the decisions of the third and fourth respondents, the Rulashai Commission and the Khatla Commission. Would you have a look, please, at volume 3 of the record at page 253? Volume 3, page 253, paragraph 18.1. Let me know if you are there, please, Mr. De Silva.
Certainly. Yes, you said page 253.
Volume 3,
yes.
18.1.
Yes.
I'm reading the second sentence. I do not agree with the findings of the commissions, but I have been advised that at this stage the findings are irrelevant and that I should not deal with the findings. It is uncertain whether Rulashai's commission's findings are in fact part of the record. It repeats that assertion in 18.2, says that's irrelevant. As I understand it, then when you read Judge President's judgment, Makoba JP, he seems to indicate that that challenge was not further pursued before the High Court. And I just want to have absolute clarity that all we are concerned with here today, in the light of all of this, is that you are only challenging the first respondent's decision, the Premier's decision.
My answer to Justice Jafta, and I make that submission again with respect, Justice Majid, one must look, first of all, one must bear in mind what the appellant says. He says, I've been advised at this stage that the findings are irrelevant. Now, that has to do with the admissibility of the record, and that was part of the argument in the quota quo. What the appellant is saying, he says that the commission's findings are irrelevant because they have not been admitted correctly. They're inadmissible. And what one must bear in mind is that at the end of the replying affidavit, the replying affidavit that you've referred me to, Justice Majid, if one turns to page 261, volume 3, he says, in the premises, I respectfully request the Honourable Court to grant an order in terms of the notice of motion. He asked for the relief in terms of the notice of motion. And then he filed a further replying affidavit. And in the further replying affidavit, he says exactly the same. He says at the end of the second replying affidavit that he seeks relief in terms of the notice of motion. So my submission to this Honourable Court is, with respect, he hasn't abandoned that relief, but we focus principally on the provisions of section 12, 13 and 30, and more importantly, on the decision by the Premier.
That does bring a further problem to the fore, and that is that the respondent, the fifth respondent, submits that you are the party that placed these commission reports before the court as evidence, and that admissibility was never challenged in the High Court. And now you're shifting ground and challenging it here. And I just want to have clarity on that.
That's not correct, with respect. One must see the process, how the process works in a review application. Rule 53 regulates how a review application is conducted.
So can I cut that short and just say, Mr. De Silva, we understand how the rule works. Are you saying that the record was produced and that is how it was placed before the court as part of the Rule 53 record? Is that what you're saying?
What we submit with respect is that the State Attorney provided the record in 2 tranches, and my attorney, in terms of Rule 53.4 or 53.3, merely collated the documents that he received from the State Attorney and placed the record before the quota quo. If you look at volume 1, at the end of volume 1, there's a certificate that was signed by my instructing attorney. If you turn to page 105, he says, I do hereby verify that this copy of the record is a true copy of the record and supplementary record as filed by the State Attorney on respectively 27 July and 5 September 2017. So all he basically did is he collated the record and he put the record before the court. Now, what is important is that on several occasions, in the replying affidavit, and I know it's a replying affidavit, but for example, if you turn to volume 3, at page 249, paragraph 10.1, paragraph 10.1 at page 249, it says, there is no evidence on oath relating to the Commission's reports before this Honourable Court, and the evidence tendered by the fifth respondent constitutes inadmissible hearsay evidence. He says that at page 249. Then if you turn to page 253, at paragraph 18.1, he says, I've already pointed out that the evidence of the 2 commissions is not before this Honourable Court under oath. I do not agree with the findings of the Commission, but I've been advised that at this stage the findings are irrelevant and that I should not deal with the findings. It's uncertain whether the Ralushai Commission's findings is in fact part of the record. And then he says that again at page 256, paragraph 25.1. 25.1 is this: I've already pointed out that the evidence of the two commissions are not properly before the Honourable Court and are irrelevant for the purposes of this application. And he says exactly the same in volume 4. But what the point I wish to make is the following. This replying affidavit that I'm reading from starts at page 245. It was filed on the 13th of September, 2018. After this affidavit, replying affidavit was filed, the first to fourth respondents filed their answering affidavit. You'll find the answering affidavit at page 268. The answering affidavit was filed 2 weeks later on the 30th of October 2018. Obviously, the first two fourth respondents had sight of the replying affidavit, and they knew that the appellant was placing the admissibility of the record in issue. The person that opposes to the affidavit is Mr. Moshlala. And if you turn to page 269 at paragraph 1.6, it says both records of the third and fourth respondents are kept by the office of the second respondent. This is because the office of the second respondent is responsible for the administration of the Limpopo province. He was the person that could have put a full record and the proper record before the court, and they never did that. They had
Mr. De Silva, I get your point. Your point is that you are still contesting the admissibility, and secondly, you haven't abandoned the challenge against third and fourth respondents.
Yes,
that was
in short,
Thank
yes.
you.
Yes.
Thank you.
Thank you, Justice Madrid.
Mr. Da Silva, Mr. Da Silva, can you just please, or maybe let me preface my question with this. Whether or not what I'm going to ask will be relevant in the end will depend on what we finally decide on the issue that was raised by my brothers, Justices Jafta and Majid, with regard to what the challenge before us right now is. For clarity's sake, let me still ask the question. The Kgabagare Commission, the fourth respondent, what exactly was that? What exactly, what entity in law was that exactly?
It's a committee that was appointed in terms of the Framework Act. Justice Langa, you'll see there are provisions in the Framework Act which
is
creates
it in terms of 26 upper letter A.
Yes, you'll see if we look at volume 2, the way the fourth respondent is cited in the founding affidavit, that might give you an answer.
So you're saying it's a committee in terms of section 26 uppercase A of the Framework Act?
Yes, you'll see we cited the fourth on page 116. Yes. Volume 2, page 116. We cite the fourth respondent established by the first respondent in terms of section 23 of the Framework Act 2003. So Justice Madlanga, you referring 26A, I think that was most probably after the amendment of the 2009 amendment. But we saw, yes. It appears that you're correct, Justice Madlanga. It's a committee it's a provincial committee. It's not the plenary commission, the full commission. It's a provincial committee which is established.
Okay, no, I just wanted to get an idea, because I wanted to know how exactly it features in the decision-making process.
Yes.
Thank you very much, Mr. Da Silva.
May it please you, Justice Madlanga.
Mr. Da Silva, can I clarify something that also arose out of your debate with Justice Jafta? You said that one of the problems was that the approval letter in page 36 seems to be relieving your client, the applicant, in terms of section 13 of the Limpopo Act, and to be recognizing the, I think it's the 5th respondent in terms of section 12(1)(b). You said that the Premier was not acting in terms of section 30. Is my recollection correct?
Justice Chiki, your recollection is correct, and the answer is fairly simple in the sense that
no, I've got a follow-up question. I just wanted to check whether I recall the debate correctly.
Yes, you do. We submit that.
Can I interject before
Yes,
before you
certainly.
make your submissions? Can we go to page 18 of volume 1, where the recommendations of the committee are? You will see that in those recommendations, in fact, the approval letters are actually couched the same way that the committee recommended.
Yes.
Look at that. And I'm referring you to this because during that debate, I was worried, and my concern is whether, in fact, what was happening here was that the Premier was acting in terms of section 30, but couched the recommendations as they are couched by the committee, meaning therefore that we should not hold that he was acting in terms of section 12(1)(c) and 12(1)(b) and 13(1)(c). He was simply saying that those sections deal with the removal and restoration. But in fact, he was exercising the power as contemplated in section 30. I don't know if my question is clear.
Justice Chiki, the answer to that lies, if I may refer you to volume 3 at page 276. This is the answering affidavit by the 1st to 4th respondents. In other words, it's an answering affidavit by the Premier. And if you turn to page 276, paragraph 6.4, Mr. Moshlala says, I deny that the first respondent's decision is not authorized by the empowering legislation and/or is ultra vires. As indicated in the following paragraphs, the chairperson of the House as confirmatory affidavit. The only provision which has not been complied with is section 30 of the Act. I am advised and submit that such non-compliance does not nullify the appointment. Common cause that section 30 was never applied. It was never applied. They concede section 30 was never applied. So in other words, where the Premier received a recommendation and had to place it before the House of traditional leaders, that never happened. That never took place.
But it's not clear which subsection that affidavit is referring to. It could be that the subsection they are referring to concerns subsections, I think it's subsection 1 and 2. 1, the one that deals with yes, 1 and 2, section 31 and 2, the ones that deal with seeking an advice. But there is no specific reference to section 33.
Justice Chiki, one sees that the deponent is a director. He's the director responsible for traditional affairs in the Department of Cooperative Governance. And what he says is, he says, the only provision which have not been complied with is section 30. If they had not complied with 32 or 33, they would have said so. They say, we have not complied with section 30. The only interpretation with respect on on reading paragraph 6.4 is that the whole of section 30 has not been complied with.
No, I think my questions arise from whether we should place emphasis on substance or on form, and this is what bothers me, because it seems to me that even the committee thought that when you remove a current incumbent, you have to do so in terms of section 12(1)(c), and read with section 13(1)(c), and that when you then recognize the other one, you do it in terms of section 12(1)(b). Because when I look at what was recommended by the Premier, it seems to me that it actually follows the wording that was in the recommendation of the committee. And what I was testing really with you was whether we should not focus on the fact that when the Premier was exercising these functions, it was actually implementing the decisions of the Commission. And therefore, the section that is relevant is section 30.
Well, I would have expected, with respect, Justice Chiki, if they were implementing the provisions of, or the recommendations of the Commission, then they would have said so, and they would have said, but we've applied section 30. This is what we did. The difficulty they have is that if they had placed the recommendations of the Commission before the House of Traditional Leaders, there must be documents, there must be a paper trail tracing what they did. And obviously there's no such paper trail, and they realize they haven't complied with. But a further aspect that we submit, this Honourable Court should take into account, is that if one looks at the recommendations, if one looks at the recommendations by the committee as set out in page 18 and compared it to what the Premier approved, on the face of it, it looks very much, they seem to be very similar. But in fact, what happened is that the MEC recommended the approval. You'll see if you look at page 36, there's a recommendation, and then the MEC signs, he says recommended for approval, MEC. And then what the Premier did is he approved what the MEC recommended. He didn't approve. If one looks at this document at page 36 and interprets the document, we submit with respect, what the Premier did is he approved the recommendation of the MEC. With respect.
Thanks, Mr. Tasilva.
May I just take an instruction? I submit with respect that I don't believe it'll serve any purpose me going through my heads. I assume, I know this Honourable Court has read through all the heads, and there was a question put to me, if I remember correctly, I think it was by Justice Theron, whether we persist with the non-compliance of the procedural fairness. Our answer is yes, we still persist with that. We deal with our heads at page 36, paragraph 6, with the admissibility of the record. We submit the record is inadmissible. My learned friends make various submissions in regard to the admissibility. I can state quite categorically that the question of admissibility was argued by me in front of Justice Kgabagare. I pertinently raised this issue. I can particularly remember examples I used in illustrating how one proves the content of a document. My learned friends allude, for example, to the provisions of section 18(1) of the Civil Proceedings Evidence Act. They submit, it's a public document. We submit, it's not a public document, because if it was a public document, the public would have access to it and they wouldn't refer us to the provisions of applying for the document. There's no evidence that the public have access to it. But what's more important is if one looks at section 18.1, on which my learned friends rely, subsection 18.1 says, whenever any book or other document is of such public nature as to be admissible in evidence on its mere production, in other words, if it's a public document, proper custody, any copy thereof or extract therefrom proved to be an examined copy or extract or purporting to be signed and certified as a true copy or extract by the officer in whose custody the original is entrusted shall be admissible in evidence. The copies that are before that were before the court are quo and contained in volume 1. They're not certified and they do not comply with section 18.1 with respect. So we submit with respect, as far as the record is concerned, it's inadmissible. And then the findings of the Kgabagare Commission we deal with at paragraph 7. So to conclude, we request this honorable court with respect to grant an order in terms of prayers, paragraph 8.2 of our heads of argument. My learner junior wants to inform me of something. Would you please bear with me? I'm not sure if the honorable court wishes to take a tea adjournment at this stage.
No, Mr. Da Silva, we do not intend to take a tea adjournment.
May it please you. Those are my submissions. Sorry, my learner junior wishes to discuss something.
That indeed required the tea adjournment, Mr. Da Silva.
I'm not sure if the suggestion is there's a tea adjournment or not.
No, it does not. It does not lie. It does not lie with me to say so. It lies with my sister presiding. I'm just saying the instructions you are getting from your junior are taking very long. It seems you actually required the tea adjournment to take.
Mate, please, you buy.
That's what I mean.
Yes.
And please don't take me seriously.
Yes. May I request a short adjournment that I can just get a full instruction, Acting Deputy Chief Justice, if that would be convenient.
How long an adjournment should we?
10 minutes. 10 minutes at the most.
Will 5 minutes be sufficient, Mr.
5 minutes would be sufficient, yes.
Yes. The court is adjourned for 5 minutes.
May it please you. I'm indebted to the Honorable Court.
Court will adjourn until 11:40. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 11:40. Should you exit, you may use the same link to rejoin the hearing.
Ms. Kuvuza,
Acting Deputy Chief Justice and Justices of this Constitutional Court, all counsel are online.
thank you. Mr. Da Silva, you've been given a latitude that is not ordinarily granted to counsel in this court.
I'm sorry to interrupt you, Acting Deputy Chief Justice. Please, can we check if Justice Jafta and Justice Pillay have rejoined us?
Oh, thank you.
I think we may proceed, Acting Deputy Chief Justice. I will communicate with Justice Pillay.
Is she not with us?
Her camera may just be turned off, Justice Kampepe.
Okay, let's ascertain if she is with us.
All the judges are online, Justice Kampepe.
Thank you. Yes, Mr. Da Silva.
May it please you, Acting Deputy Chief Justice, I'm indebted to the Honourable Court for the indulgence this court has given the appellant. We want to make one final submission. It turns on the interpretation of Section 30. I've already made the submission that Section 2.1 says that the Limpopo Act is subject to the Framework Act. But we submit with respect that when one interprets provincial legislation and national legislation, one should take into account the provisions of Section 146(2) of the Constitution, which deals with conflicts between national and provincial legislation. And in particular, Section 146 sub 2b says the national legislation deals with a matter that to be dealt with effectively requires uniformity across the nation, and the national legislation provides that uniformity by establishing norms and standards, frameworks, or national policies. Now, if one looks at the Framework Act, there's a similar provision in the preamble. It reads, whereas the state in accordance with the Constitution seeks, and then the first bullet point, to set out a national framework and norms and standards that will define the place and role of traditional leadership within the new system of democratic governance. Now, the submission we wish to make is that the amendment to the Framework Act in Section 26, where the amendment was brought about on the 25th of January 2010, changing decision to recommendation, is a fundamental change that was brought about. And that has an impact, we submit with respect, on an interpretation of Section 30. So when one interprets Section 30 of the Limpopo Act, one must read in instead of decision recommendation. So sub 1 should read, the Premier must within 7 days of receipt of the recommendation of the Commission. And then sub 2, also the word recommendation. And then sub 3, the Premier must implement the recommendation of the Commission. So one cannot implement a recommendation. So one should interpret subsection 3 on the basis that the Premier must consider the recommendation of the Commission. We submit that's how one should interpret subsection 3 to Section 30. So only after the Premier has considered the recommendation of the Commission, Then, after consideration, he arrives at a decision. So one theoretically is faced with a situation that the Premier could in fact make a decision which goes against the recommendations of the Commission. And that accords with the Framework Act, because Section 26.5
Yes,
of
Mr.
26
De Silva,
Yes,
I'm sorry to interrupt you, but I was just going to take you to the Framework Act, Section
Yes.
26(3) and 4.
yes,
That is how the Premier must exercise whatever powers he has or she
Yes.
has.
yes. So we submit that 26.4 overrides the provisions of Section 30, yes. So the only difference is if he goes against the recommendations of a commission, then he must give reasons. That's the only difference. Those are our submissions. May it please you.
Thank you, Mr. Da Silva. Mr. Pieker.
I'm indebted to the court.
Is it correct, Mr. Pieker, is it correct that you will not take your 10 minutes protection time?
That is indeed correct, Justice.
Thank you, Mr. Pieker.
Thank you very much. The first aspect we wish to deal with briefly is the contention raised by learned friends that, in fact, there is still a challenge to the decisions that were taken by the commissions, and we submit that it has been formally abandoned. My learned friend referred to certain passages and addressed you on the basis that the reason for not pursuing it at the time was simply because they considered it to be hearsay evidence and therefore of no value, and therefore not pursued. However, the one passage that he didn't quote is at page 254 of the record, that is at volume 3 of the record, and that appears at paragraph 18.4, by way of summary, if I may read this. Quote, as has been pointed out, the Commission's findings are irrelevant in that I'm not taking the Commission's findings on review, but the first respondent's decision to appoint the fifth respondent on review. So the question of the documents being inadmissible and therefore no reliance could be placed on it doesn't appear from this paragraph. What appears in this paragraph is there's a shift of focus, and instead of taking the Commission's findings on review, the alternative decision was taken, and that is the decision to appoint the fifth respondent on review. That in itself, we submit, is not in accordance with what was sought in the notice of motion. In the notice of motion, what was sought, it was a challenge to the removal of the applicant in this application from his position. So that doesn't even accord with paragraph 18.4. The challenge was not to the decision to appoint the fifth respondent in terms of section 12. The challenge was really the removal of the applicant in terms of section 13. So we submit that there is no challenge as it stands at the moment against the either commission or against the decision of the royal family. So it serves no purpose to criticize the meetings of the royal family. There's no purpose in examining when a quorum was met. With respect, there's no evidence of this 2/3 or 66% quorum that we see in the heads of argument. There was no evidence led to that effect. But in any event, the challenge that is made presently does not lie against the Commission's findings, and it doesn't lie against the royal family. That being the case, if one considers the decision in Oudekraal, means that they are enforceable, and the challenge today can only be to the conduct of the Premier, but on the basis then that the Commission's findings were correctly arrived at, and that the royal family's decision was correctly arrived at, we only consider the conduct of the Premier.
Mr. Pieker, I understand how the Kgabagare Commission features I would understand the relevance of the Ralushai Commission insofar as evidentiary matter is concerned. But now you refer to eau de Kral and you talk about the decisions, and I assume you are referring to both commissions, and you say on the basis of eau de Kral both stand. I do not understand what the relevance of any decisions that were taken in the Ralushai or by the Ralushai Commission, what the relevance of those is. That was set up in the 90s, before the Framework Act, before the Limpopo Act. What's the relevance of the decision? Outside of, you see, the evidentiary material is different altogether. Maybe you may say something about that, but as I say, that's something else altogether. But the decision, I do not quite get what the relevance of that is.
Both of these structures, provincial committees serving the purpose of a commission appointed of some experts, went through, was probably best described as a quasi-judicial process where evidence was led, witnesses were consulted, etc. And they made a finding, and it may not be the finding of a court of law, but it is the finding of a tribunal.
I'm very sorry to come in. Yes. When you refer to decisions of commissions, I just want to establish for clarity, are you including in those decisions the decision or decisions of the Ralushai Commission?
Yes, Justice Langa.
Yes. Now my point is, I hear your point about their nature and so on, which you had started addressing on before I intervened. My point is a slightly different one. I'm saying, you'll correct me if I'm wrong, the Ralushai Commission was set up in the 90s. Am I
correct?
Yes.
And nothing came of that.
Yes. Now my point is, we are here concerned about decisions or actions taken in terms of the Framework Act and or the Limpopo Act. Both of those are in the 2000s.
Yes.
Now, what I'm saying is, how can a decision of the Ralushai Commission be of relevance if the Ralushai Commission was set up in the 90s, and obviously then it predates both acts. It predates both acts.
Correct. I have to agree with you, Justice Mandlanga. The Ralushai Commission, I think the purpose that it serves in this matter and the reliance that's been placed on it thus far is simply that the consistent finding was brought out in the Ralushai Commission as well as in the Khatla Commission.
That's exactly the point. Yeah. That's exactly the point I made right at the beginning. I said, I'm teasing out or I'm separating the question of decision as opposed to evidentiary matter.
Yes.
But now you seemed to be referring to decisions, and I just didn't see how the decision of the Ralushai Commission could be of any relevance.
Absolutely, I have to agree with that. The Khatla Commission, of course, stands on a different footing. It's much more recent, and that appears to be the resolution, and the recommendation that was sought to be implemented by the Premier is the Khatla Commission. So the evidence.
Would the commission, the committee, would it have been acting in terms of Section 25 to?
It would have been the old.
Of the Framework Act.
The Framework Act.
Now,
well, that initially it was a national commission and then provincial.
Okay, and now the Premier would have been acting in terms of Section 30 of the Limpopo Act, or not?
Indeed.
Yes.
Indeed.
But now your colleague, Mr. Da Silva, read a passage from your clients, not your clients, but
correct.
One of the state functionaries' affidavits, which says that there was totally no compliance with section 30.
I don't think he says totally. I submit that it's all in a draftsmanship. What was, and I don't want to give an alternative version of what the evidence may mean.
Yes.
But what we do know is that there wasn't strict compliance with section 30 because the time periods were not followed. The Premier did not within 7 days of receipt to the Commission do that. The Provincial House didn't submit his advice. So I submit, and I don't want to put a different gloss on the evidence, but it appears that was a concession that was too easily made and is far too encompassing. Because what we do know is
was the advice of the Provincial House sorted all?
The advice was not sought, but the advice would be the advice on implementation. And if I may just comment on what my learned friend said about that topic, their contention is that if it's about implementation, that advice that is returned may be that it should not be implemented. We disagree with that. It is about, it is not on all fours. It would negate the purpose of advice if the advice is, here's your recommendation, but in fact, we're not going to implement it. We submit that the kind of advice that's envisaged in section 30, sub 2, is the advice on how to implement, in the sense that, and I think His Lordship, Mr. Justice Makoba said in his judgment, you cannot have two bulls in one kraal. So if the one senior traditional leader is appointed the rightful one, then obviously the counter side of that argument must be, or of the finding must be, then the incumbent or the region for the moment must have been wrongfully appointed or wrongfully recognized in terms of 13(1)(c). And that, of course, brings us to the question that has come up from the court a few times, and that is, who implements it? If we accept that section 13 sets out the various grounds upon which royal duties may be relieved, and we see that the royal family will be able to indicate A, B, D, and E. It will be on their initiative that these are followed.
I'm still, before you go to all of those, I'm interested in implementation. So I was saying that implementation relates only to what? Just repeat that submission, please.
The implementation, my learned friend's argument, perhaps if I set out the contrast.
I want yours, please. I want yours.
Yes. What we say, it was in fact implemented. We see that at page, for instance, page 79 of the record in volume 1. That is the letter that was addressed by Limpopo provincial government, the district manager, relief of royal duties. The Premier has, in terms of that, approved the duties. We submit that is part of the implementation. Similarly,
no, Mr. Baker, I want you at an interpretation level, statutory interpretation level, to tell me what your understanding of implementation or in sections 30 sub 1 is. What does implementation there mean? I'm not referring to what the functionaries may have said or done with regard to what they consider to be implementation. What does that mean?
Indeed, what one will have in the case of let's say a wrongful appointment of a particular incumbent or wrongful recognition of a particular region is that you would have the house may be seated in a particular village, or it may be claimed by a particular clan. There'll be books, there'll be records, there'll be furniture, etc. Monies will be received, there'll be a bank account, etc. of monies that get paid in. So all the records of the traditional community will be kept in one place, and advice on implementation we submit would be simply the practical measures to be employed by the House to ensure that this change is implemented. I.e., yes, let us, for instance, provide the existing regent with a month to vacate his office. Let's transfer the bank account to new signatories. Let us move the royal kraal from here to there. Let us appoint new functionaries, etc. So we would submit that the interpretation of section 31 about the advice on implementation would be that the Premier would communicate with the House, and the House would advise him and say, we hear your recommendation that A be appointed instead of B, but in order to effect that, to implement it, what we suggest is the following: let that happen within that time frame, let's do that, and then let's do that, let's have an inauguration on such and such a date, and then the process would have been completed. We submit that these are all the practical measures, simply practical measures to fall into place.
Why does it not encompass whether the recommendation of the committee should be implemented at all? Why that restrictive interpretation?
We respectfully submit that it is clear that the decision has been taken, and that the Provincial House of Traditional Leaders would not have the power to negate or to veto the recommendation that is made, simply because it doesn't have its own powers of investigation. It doesn't have its own decision-making powers in respect of, let's say, the wrongful appointment, i.e.
It would not be negating. It would not be negating, because even what the committee has done is to recommend. It has not decided, and the decision is to be taken by the Premier. So it's not negating. All that it would be doing is to have an input on whether or not the recommendation should be implemented. Why is that not so? Why should that not be so? Why should we be so restrictive? Also bear in mind that the people who make up the provincial house are people who are steeped in traditional affairs. They themselves, if I were to use the language, are practitioners in that field. So it's not that you would be asking me about traditional leadership affairs. It's people with expertise and whose input would actually make sense. And even if they don't have, as you say, investigative powers and all that, but what comes from the committee will obviously serve before them. There will be no point for the Premier to seek advice if the Premier is not going to say, here's what I received. And then they are going to go through all of that, and they are going to be able, or at least they should be able to have a meaningful input. So why should we be restrictive in our interpretation?
Perhaps the answer to that, Justice Langa, perhaps the answer to that lies in the approach that is prescribed by section 211(3) of the Constitution. And that is the decision we referred to on page 4, paragraph 5 of our heads, with an insightful, respectful quote, where it talks about the flexible nature of customary law. And it says it is profoundly different to other legal systems, but it is an enriching factors. And it sets out that we got a quote from the judgment, reading from paragraph 5 of my heads. If we are serious about giving, and this is this court, if we are serious about giving customary law its rightful place under the Constitution, it would be prudent to allow it to develop in its own intrinsic way, in accordance with the fundamental values and rights protected in the Constitution. So the question is, what is the ambit that one ascribes to implementation? If implementation is given the interpretation that you refer to as a narrow interpretation, it simply means the mechanics, the nuts and the bolts of moving this there, and that person comes in and that one goes out, etc., etc. On a wider interpretation of that advice could be, but let us not implement the decision at all. And that would, with respect, cause a conundrum, because the Premier is obliged to take these steps, but we do not see in the Act that he is obliged to take this advice into consideration or even to apply his mind, or that, for instance, badger would come into play if he does not follow the advice or the recommendation. I think we need to see it against the background of traditional structures and not to follow too narrowly contextual an approach, quoting from
in terms of what is the Premier obliged?
In terms of
I know in section 12 it says must, subject to some other section or subsection, but where in the context of section 30 does it say must? I'm not saying it doesn't say so, maybe it does.
Yes. What it says, if I may just read from 30 sub 3, and we submit this, that is the one that was in fact implemented, and we submit that it is in fact a standalone clause, standalone section, not to be read in conjunction with sub 1 and 2, but it reads, the Premier must implement the decision of the Commission within 30 days of receipt of the decision from the Commission. So is the decision of the Commission...
No, Mr. Pieker, that goes to the when. The 30 days is a terminal point. It has nothing to do with a decision. It has nothing to do with it being obligatory that the Premier must simply take what the committee said. Because why else would it be called a recommendation if it's obligatory?
Well,
the must in subsection 3 does not assist you at all, Mr. Pieker. I don't think. So where else?
With respect, we cannot accept that point. If the must in section 33 relates to within 30 days, if that is the emphasis as one places, then you ask yourself what happens if that's the imperative part of the clause, they must implement, and it doesn't happen within 30 days. Then if it's 31 days, 32 days is invalid.
That's a question I'm actually going to put to you. If you remember when your colleague Mr. Da Silva was arguing, I actually put that question to him as well. So it's a question that you should actually answer.
Thank you, Justice. Justice, we submitted the emphasis in 33, or let's say if we look at the heading of section 30, it talks about the implementation of the decisions, and then it creates 3 obligatory steps that must be followed. The Premier must within 7 days, Provincial House must within 14 days, and then thirdly, the Premier must implement the decision of the Commission within 30 days. We submit that the emphasis is on the must implement the decision of the committee, and that the 30 days is merely directory to say, well, do it within 30 days. That 30 days, of course, is a very, very short period and doesn't allow for any of the procedures, or practically would not allow, we submit, for any of the procedures in terms of PAJA to be given effect to. It is such a tight time frame that it cannot be read into this Act, but this should similarly take account of any steps in terms of PAJA to afford somebody a proper hearing. And it doesn't give the Premier the power to hear any further submissions or to receive any further recommendations. So we submit that it should act strictly in accordance with these provisions. And we submit that the emphasis on section 30 should be on the must implement and not on the 30 days. If the 30 days are then exceeded, we respectfully submit that would not invalidate the decision. And I think that's also said in the decision of Ludidi. It doesn't invalidate the decision. There may be non-compliance, there may be late compliance, but as long as there's substantial compliance, we respectfully submit section 33 would have been complied with. We agreed that the powers are derived from 13, and that the Premier, that the grounds derive from section 13(1)(c). And the question that has been put also to my learned friend is, who must then implement that?
May I ask just one last question before you move on?
Of course, Justice. Of course.
Thank you, Mr. Bieker. I'm sorry. Let me suggest to you another possible basis for why subsection 1 should not be interpreted as restrictively as you suggest. The effect of the recommendation and a decision by the Premier would be divesting somebody of a position, and an important one at that. It comes with income, status, and all of those things. And I would say, and this is a position also, perhaps more importantly, that receives crucial recognition from the Constitution itself. Isn't that reason enough for not reading subsection 1 of section 30 as restrictively, or implement, the word implement or implementation, as restrictively as you suggest we should read it?
With respect, we submit not. And the reason is that the decisions, the two decisions, we should say should either have been taken by the provincial committee, i.e. the commission, or by the royal family. These are the two entities that have the power in law to consider, hear representations, hear submissions, and to arrive at a particular decision. So the complaints, the hearing, the alteram aspect, the section 3.2 aspect of PAJA, we submit all of that is confined to either the royal family or the provincial committee, and that the Premier does not have that power, regardless of the language used, the recommendation. Perhaps there's a difficulty with using the word decision in the case of a commission, because it is not a court of law. We attach a particular technical decision to what is a decision. But even if it is decision, it is with respect also not to say that it's a decision which constitutes administrative action in terms of PAJA. It may be another type of decision that does not have the same status or value as an administrative action as contemplated in PAJA, and therefore that even if it amounts to a decision, is not a kind of decision that can be tested. But we submit that the mechanism, the true forum for raising these disputes and for the audi alteram, does not rest with the Premier. We submit that he is merely a functionary and that he goes through the process of implementing as he is obliged to do. So we submit that it doesn't involve a decision for him to implement Rule 30, the Section 30, but even if it does, we submit that type of decision does not attract the obligation to give somebody a fair hearing before it is made.
Thank you,
Mr. Becker. Must Section 30 of the Limpopo Act not be read with Section 26, 3 and 4 of the Framework Act? And that section makes it clear that the Premier has a discretion. Subsection 3 says the Premier has 40 days within which to make a decision on the recommendation. Subsection 4 specifically says that if the Premier takes a decision that is different from the recommendation, he must provide written reasons for that. And we've already established that Section 30 of the Limpopo Act was not amended subsequent to the amendment of the Framework Act, which gives the Premier that discretion. I think we have to accept that the Premier is not just a functionary that must implement. In terms of the current Framework Act, the Premier has a discretion. Now, once we accept he has a discretion, doesn't it then become necessary for him to give at least the applicant a hearing as to how that discretion should be exercised?
We submit that the discretion that the Framework Act Section 26 talks about is not the same type of discretion as we consider necessary for purposes of PAJA. The hearing, and that connects to the previous point we made. If there may be a discretion, it may not be an administrative discretion. It may not be tested by PAJA. In reality, somebody would have made his submissions, would have been cross-examined, and a finding would have been made, and the result of that is presented to the Premier for implementation. If the Premier's decision or discretion in terms of the Framework Act would extend to basically rehearing all the evidence, then it would, I won't say negate, but it would duplicate the whole procedure, because he would rehear the evidence in order to come to his own.
I'm sorry to interrupt you, Mr. Baker.
Certainly.
The Framework Act doesn't say he needs to rehear the evidence or what he needs to do. The Framework Act simply says, if he decides not to implement the recommendation, the Framework Act gives him the power to make a different decision to that was recommended by the Commission. Obviously, he must exercise that discretion properly. But at the end of the day, he has the discretion, he has the power to make a different decision.
Yeah, I agree.
And the process he follows to do that is not stipulated in the Framework Act. But that is stipulated in the Limpopo Act.
Yes, yes. But we submit that the discretion which we see in the Framework Act is not the type of discretion to involve a rehearing. There may be, or following any other process, there may be reasons why a Premier may not wish to implement a recommendation. It may be for various practical reasons. It may be too dangerous, it may be inopportune, it may be that the regent is too young, or whatever the concerns. But we submit that it would not necessarily mean hearing the parties again and considering the same evidence that was delivered in front of the Commission, and as it were, usurping their task. We submit that this discretion is somewhat different, and the exercise of that discretion does not necessarily entail involving the complainant or the relevant parties in order to apply audi alteram partem to them. It may be discretion that's exercised, although it's got these consequences, but for considerations other than not believing the evidence or not being satisfied with the result of the recommendation, we submit it would be confined to that, and that PAJA would not be applicable to that, and one should rather look at section 12 and 13 of the Limpopo Act for the mechanism behind it. And we submit, if we do look at these acts, or at the Limpopo Act, we see that the preemptory provisions or the provisions of section 30 that talks about the Premier must, Provincial House must, and the Premier must. And we submit that indicates that he is in effect just a functionary in order to give effect to these decisions. So I submit, if we read the Framework Act section 26 together with section 30 and 12 of the Limpopo Act, then it makes it clear that the discretion referred to in the Framework Act must be a different type of discretion, one not involving rehearing evidence or applying audi.
Mr. Becker, I think I'm getting confused now. The Commission did not hear evidence on implementation, did it?
No, no.
The person who is going to consider representations on implementation is the Premier. Is that not correct?
In terms of the Framework Act, yes. In terms of the Limpopo Act, you'll be seeking advice from the Provincial House in terms of 30 sub 2.
So why is it constitutionally objectionable for the Premier, having gotten advice from the Provincial House, to hear the person who's adversely affected by the recommendation before implementing that recommendation? Why is it constitutionally objectionable?
Because we respectfully submit that that person has already been heard.
No, but you said, but you said he was heard in relation to the recommendation itself, not its implementation. Those are two different things.
Yes.
We are dealing with implementation now. And the debate that you've been having with my colleagues is, why then is it wrong for him to be heard on implementation, not the recommendation? He can challenge the recommendation to say it's invalid or it's not, and the Premier doesn't go into the evidence of investigating whether the recommendation was properly made, is it correct or what? He looks at the implementation. Now, my question is, why should he not be heard on an issue that was not dealt with by the Commission?
Because we submit that he seeks his advice, he takes his advice from the House of Traditional Leaders as regards implementation. And that is why we ascribe so little value to the, I just want to be demeaning towards the particular clause, but why do we don't place so much emphasis on the Framework Act and rather emphasis on Section 30? Because Section 30 is a lot more pertinent and specific with regard to the implementation. And we submit that Section 32 would serve the purpose of, let's say, advising the Premier and delivering input, as opposed to a procedure where the same person that may have testified before is called back to say, yes, you have now been recommended for, let's say, for your removal, and now start with a process of implementation. The implementation, as we've submitted before, we submit cannot be a refusal to implement in whichever way it is couched, because there's an obligation for it to be implemented, for the recommendations to be implemented. So we submit there's not a discretion, will we be implementing or will we not be implementing? It's a question of the manner in which this was done. And we submit this, that is where Section 30 sub 2 of the Limpopo Act plugs the hole. And it says the Premier must then get advice from the Traditional House. How do we go about doing that? And that is the input that he receives in order to make his decision, and not through a rehearing of the particular person.
So on your argument, the Premier cannot refuse to implement.
Yes.
Is that interpretation not in conflict with the Framework Act?
Like I said, the discretion in the Framework Act, it appears to be a limited one. If we can just go to the Framework Act. Sorry, I just lost my place. Decisions of Commission. If I may just quote, for a decision of Commission is taken with the support of 2/3, a decision must within 2 weeks be conveyed to the President for immediate implementation in accordance with Section 9 or 10. That is Section 26, 2A of the Framework Act, where position of a Queen is affected by such decisions. So even Section 26(2) says a decision must within that time be conveyed to the President for immediate implementation. And it appears that that discretion was an extremely limited one. There may be reasons known to the Premier why a particular position should not prevail, but So there may be other reasons, there may be administrative reasons or constitutional reasons or practical reasons that a Premier may of his own accord wish to mention. And we submit that the discretion is confined to that, and it's not imperative that there be a rehearing, because the person who takes part, the person whose position is adversely affected, is very much part of the proceedings. He's aware of the charges being put against him. He's of the charges being put, or let's say the complaints being made against his position. He is heard. He's got a full opportunity to do that. And we say once that process has been exhausted, then it's simply a question of implementation. And we submit that this discretion of the Premier is extremely limited, and it would not involve a rehearing, but rather considerations.
It seems to me, Mr. Bamsora, it seems to me that you're conflating two issues. The one relating to the hearing of the affected person, and the other relating to the power of the Premier not to implement the recommendation. The reference to the framework was relating to the second issue, which appears clearly, subsection 3 and 4, that the Premier may differ from the recommendation. If he differs, he must give reasons. So that seems to be clear to me. That's why I have difficulty with an interpretation of the Limpopo Act, which contradicts the National Act, when we know that in the event of conflict, the National Act takes precedence. Is it not so?
Yes.
Okay. Let me go to a different issue related though. What is the purpose of getting an advice from the Provincial House?
It is advice on implementation, i.e. the Provincial House, as I said, may, and as examples I made up before, Provincial House may say, let's implement this over a period of 6 months, or let's wait for the existing regent, for instance, to die or to reach the age of 70, or as we see in some of these cases, we can implement it over a period of time, but the existing regent should, for instance, not be involved in negotiations about mining rights, etc., etc. So the
purpose is to advise the Premier on how he or she should implement. Isn't that so?
Yes, the decision would stay the same. In other words, not about the merits or demerits of the decision. It's about that the decision would stay the same. This is merely the mechanical part of it. And that is, how do we implement? And the advice we submit might take the form of either delaying it or qualifying it or leaving somebody's position for the moment. But we say that does not affect, that in itself will have a minimal effect on the person involved, because the finding is he must be replaced. So if he's replaced in a week's time or in 6 months' time, we submit that is what the advice is.
And that advice must precede, surely, the Premier's implementation.
Yes, we submit that there should be advice.
And in terms of constitutional law, we describe that which must exist before the exercise of power as a jurisdictional fact, aren't we? And if the functionary purports to exercise a power without the existence of the jurisdictional fact, that decision is regarded as invalid, isn't it?
In principle, that would be, if there's a pre-jurisdictional requirement which is absent.
Okay. I think, before I go to the last one, Mr. Baker, I think your client was let down by the provincial officials here in a number of respects. And I quite sympathize with your client. Can I take you back to page 36 of volume 1?
Thank you, I'm there.
You there?
Yes, I am, thank you.
6.1 says expressly that the applicant was removed in terms of section 13 of
Yes.
the Limpopo Act. Is that correct?
Yes, yes, it is.
Is it a correct provision?
13.1c, we submit is a more accurate description.
No, but what does 13.1c say?
That is the
Let's go to it.
relief of royal duties shall be on the grounds of wrongful appointment or recognition.
Is that 13.1? Oh, yes. No.
Yes, 13.1c.
Okay, and then who removed? Is it the premier or somebody else?
Is the premier acting on the recommendations of the commission? I.e., this is the recommendation, and that has been supported. We see on the previous page, and the recommendation made to the premier then is relieve David Langa and recognize Hans Malesela Langa. These are two. So the premier has not exercised his mind on this. This is what is the recommendation is that was made to him. And that is what he in our submission merely implemented. It wasn't his decision. It was the House that recommended the removal of the applicant on the basis of his wrongful appointment or recognition.
When you say the House, where do we find that?
I beg your pardon. Sorry, my junior just pointed out. Sorry, not the House, the Provincial Commission. I beg your pardon. The provincial committee, i.e. the commission.
Where did the provincial committee say the applicant is relieved of his duties, and in terms of what provision would they be acting? I'm asking this because my understanding of the framework is that the committee has to determine generally two issues: whether the position of traditional leadership in a particular community is legitimate.
Yes.
That's one issue. And if they have so determined, they can also determine a dispute relating to who amongst the members of the royal family is the rightful heir to the throne, so to speak. Now, can you point to me a provision that authorizes the committee or the commission to remove someone who's already on the throne?
That is what has been referred to, I think, earlier as a lacuna, because what Section 13 of the Limpopo Act does is to say, under these circumstances or on these grounds, somebody may be relieved of his royal duties. And as we've seen, A, B, D, and E is on the initiative of the royal family, and C does not say who should initiate that. So I submit that insofar as it doesn't say who's going to take the initiative or on whose instance should somebody be relieved of his or her royal duties in terms of 13.1c, I think what we would submit is that that aspect is silent. And there are essentially two authorities that pronounce and make findings and take decisions royals, and that is either the provincial commission, the provincial committee, the commission, or the royal family. We see the royal family can act on the grounds in A, B, D, and E. We don't see who can act on the grounds in 13(1)(c), and we submit absent a reference to that lying within the purview of the provincial committee, that should be something which the provincial committee should comment on. I beg your pardon, I got my words wrong there. What I'm saying is, in the absence of it being indicated who would have the power to act in accordance or on the ground of 13(1)(c), we submit that can only be on the recommendation of a commission, because that is not the royal family's call. So it, with respect, can only be the commission, and that links up, we submit with section 30 sub 3, which says the Premier must implement the decision of the commission within 30 days. The recommendation of the decision of the commission was twofold: simultaneously appoint the one and remove the other. The one is a counterside of the other. One can't have two senior traditional leaders. So we submit that insofar as 13(1)(c) is silent, one should read it in conjunction with section 30 sub 3. It simply says the decision of the commission must be implemented.
I agree. Speaking for myself, I agree with you when you say the removal of the one already in office should come through section 30.
Yes.
Because that is the section that authorizes the implementation of the decision of the committee.
Yes.
And as we know that there cannot be two traditional leaders occupying one seat. So if there were to be implementation of the recommendation of the committee, it would mean then that the one in office already has to be removed, but through that process. Now, if that is correct, the reference to section 13 on page 36 is incorrect, is wrong. Isn't it?
I'm afraid I don't get Justice Jafta's point.
The point is, if the applicant were to be removed through the implementation of the recommendation by the committee in terms of section 30, the reference by the Premier of removal of the applicant in terms of section 13 of the Limpopo Act is wrong. Is it not?
We submit not, Justice Jafta. We don't see why it would be wrong, because the finding is a double finding. The one must make room for the other. So if one appoints in terms of section 12(1)(b), then the counter side of that is somebody who's occupying that position, if there's somebody, must simultaneously be removed. So if there's a recommendation.
The appointment is not in terms of section 12. The appointment is a recommendation. The recommendation says the rightful person to occupy this position of a traditional leader is Mr. Malisela. Premier, you have to implement that recommendation. And if the Premier follows what section 30 requires and he or she is happy about implementation, then it means that the Premier will have to issue a certificate of recognition to Mr. Malisela. The Premier doesn't appoint, doesn't remove, but the effect of issuing the certificate of recognition in respect of the same position would be that the applicant who is already on the position is kicked out.
Yes.
Isn't it? So
yes.
I am saying the Premier ought to have referred to Section 30 instead of Section 13 when he implemented or purported to implement.
But the implementation would be in terms of Section 30, the grounds upon which and the motivation and the rationale and the justification for doing so, that would be Sections 12 and Section 13 of the Limpopo Act, because that was the nature of the recommendation that was made by the provincial committee, by the commission. So what we see at page 36 is the recommendation that it be done, he relieved of his duties in terms of 13, let's read 13.1c because that's most appropriate, and that he be recognized in terms of Section 12.1b. But this document would then constitute a part somewhere in the chain of the implementation that we see in Section 30. And with respect, even if it did not say, I'm busy implementing now in terms of Section 30, and I'm implementing the decisions that were made in terms of Section 13 and 12.1b, we submit that would not detract from the validity of the implementation. If it doesn't say in terms of the powers vested in me or acting in terms of Section 30, he implements the decision and he refers to the motivation for that or the justification for that, the relief of duty in terms of Section 13 and the recognition in terms of 12.1b. I'm not sure if that addresses Justice Jafta's question.
Yes. Lastly, is there anywhere in this record, I didn't find it, where the Premier explains to us perhaps that the reference to Section 13 in his decision was in error?
I can't recall having read that, Justice.
Okay. It seems that it's not there.
It's possible.
And isn't that creating a problem for you on the authority of Minister of Education V. Harris, where this court said it doesn't matter that the decision maker had authority to do something under another provision. If they say, I have taken this decision in terms of this provision, and it turns out that the provision expressly referenced doesn't give the power. The fact that they do have the power from another provision is neither here nor there. That decision is invalid. Doesn't that decision create a problem for you?
Just with respect, we don't see it like that, because it is not a question of either acting in terms of Section 30 or in terms of Section 13 or 12.1b. It is not a choice of alternative remedies or alternative grounds that may be employed. The one relates to relief and recognition, i.e. to the formal process of establishing who is a true senior traditional leader and who does not belong there. And Section 30, we submit, deals with a completely different aspect, and that is simply the decision having been made, having been applied, how do we now implement it? So we don't see it as the recommendation of the, or put it like that the implementation process as followed by the Premier in terms of Section 30, we don't see that impacting or being at all in conflict with the provisions of sections 12 and 13. It is not as if he exercised his power in terms of that. He exercised in terms of section 13, but having regard to what preceded that, findings that were made in terms of section 12 and 13.
The problem is that in respect of section 13, the power that the Premier has is to withdraw the certificate of recognition. He doesn't have the power to remove someone.
Section 13(1)(c), I don't believe gives the Premier that power. It simply says the relief of royal duties shall be on the grounds of, and it simply sets out the grounds without allocating it to anybody. A, B, D, and E goes to the royal family. 13(1)(c), we don't know. We submit that could only be the commission.
13(3) says he may withdraw if a traditional leader is removed,
yes, from
office by the royal family, he may withdraw the certificate.
Yes.
So, but I thought your argument was no. The Premier does have the power to remove, but that power resides in section 30 when he implements the recommendation. The effect of it is to remove. I may have misunderstood your argument there.
I hope so, Justice Jafta. Thank you very much.
All right, thank you, Mr. Becker.
Mr. Becker, may I just take up this point of who makes the decision? Because if the Premier takes the decision and not simply implements a recommendation, then it means that that decision maker, surely where rights are adversely affected, must give the affected party a hearing. Do you accept that?
Yes, I do, Justice Majid.
I refer you to Sikhao, the Sikhao case. It was cited in the heads either by yourself or by the applicant. Sikhao is a decision of this court. And
I think it's cited by us.
Yeah, 2013. Now, you'll recall that in Sikhao, the question was, when the president issued a notice, whether he did so under the old Framework Act or the amended Framework Act of 2009. And the one thing that is emphasized in Sikhao, and this is the point that I want to raise with you, is that the court emphasizes the material differences between the two acts. And the court emphasizes that whereas a commission, national commission, or a committee, provincial committee in this instance, could previously had the power to make a decision, it no longer had that power. This court emphasized that it now can only make recommendations. That's the first point. The second point that this court emphasized in Sikhao is that the procedure is materially different. It says so in terms, in section, in paragraphs 27, 27 of the judgment, and then you got to read the footnotes with it. The point that this court makes is this: it cites these provisions. It cites the old section 10 of the Framework Act, and in contradistinction, it cites section 26 of the amended Act. The point that this court makes is this: whereas previously the Commission could make a decision, and in terms of the old Framework Act, the 2003 Act, the Premier or the President, in this Sikhao it was the President, must implement that decision. It points out then that under the amended Act, in terms of section 26, that recommendation must be conveyed to the President, or in this instance, the Premier, and the Premier or the President, as the case may be, must then independently take a decision on that recommendation. Do you understand the difference?
Yes, I do.
It seems to me then that taken with section 2 of the Limpopo Act, which says that the Framework Act takes precedence, and section 146(2)(b) of the Constitution, which says that if there's a conflict then the National Act must take precedence if it creates uniformity or norms and standards. And we know that the Framework Act does that. It says so in its preamble. And therefore, it seems to me that if you read all of this, it seems to me that it is the Framework Act, particularly sections 26.3 and section 26.4 of the amended Framework Act of 2009 that applies here. In other words, it's not the Limpopo Act that applies, but the Framework Act. And that means that what the Premier did here was to exercise a true discretion in assessing, considering that recommendation, because it couldn't be a decision, it could only be a recommendation. Make an assessment and consider that recommendation, and then took a decision adversely affecting the applicant in terms of section 26.3 and 26.4 of the amended Framework Act.
Yes, I think when the same issue was brought up, perhaps not in the same terms as your Lordship, Justice Manjit framed it. Now, the response was, just have a look, that whilst section 26 sub 3 of the new Framework Act does talk about a decision. It says if the president, to remove the recommendation must, no, sub 4, if the president or relevant functionary takes a decision that differs with the recommendation conveyed in terms of subsection 2, etc. So it talks about a decision differing with the recommendation. It does not say takes a decision to replace the recommendation or to take its part or to assume the role of rehearing the evidence and reconsidering it. So whilst that is what it doesn't say. So we submit that decision that is contemplated in there is not an administrative act as required by PAJA. Sure, he has to apply his mind. Sure, like anything else, a decision is going to be taken reasonably, etc., and so on. But what we're concerned with, particularly in this application for leave to appeal, is whether there should have been an opportunity, a further opportunity afforded to be heard by somebody whose rights may be affected. And we submit that cannot be read into section 26 of the Framework Act. Yes, it may be a decision. No, we submit not the type of decision that's administrative action and that would invoke the provisions of PAJA.
You see, my difficulty, Mr. Becker, is the one raised by, I think my brother Langa raised it. How do you implement a recommendation? Which is what the Limpopo Act, what you would have us have the Limpopo Act do in section 30 sub 3. How do you implement a recommendation? Because it cannot be a decision. We must accept, you and I, that the Limpopo Act, whenever it speaks of a decision made by the commission, by the provincial committee, when it talks about that decision in section 30, it cannot mean a decision. It must mean a recommendation because it must be read subject to the Framework Act. Agreed?
Yes.
So how do you implement a recommendation? The point is you can only implement a decision and you must read. When you read Sikhaw is very pertinent because it was crucial to the ratio decidendi in that case, Mr. Becker. This court had to consider very carefully. When the president issued a notice which affected the applicants in that case, the Sikhaws of the Amapondo tribe, the court had to consider, was this notice properly issued? Was it issued under the old Framework Act of 2003 or was it issued under the amended Framework Act of 2009? Of course, the court made exactly the point that my brother Jafta made and referred to Minister of Education versus Harris and said, you can't take a decision under a certain act and says, well, I may have taken that decision under the wrong act, but nonetheless, I took the decision. This court in Harris pertinently said, you must identify the empowering provision under which you take that decision. And so surely here, it must be the Framework Act that applies, section 26.3 in particular.
But not exclusively. It would be that then with respect read in conjunction with the Limpopo Act and section 30 in particular of the Limpopo Act relating to the implementation of that decision. What one understands is that between the old act and the new Framework Act is if the method of arriving at the decision and the status of that decision was different in terms of the old act, in terms of the new act, as it was to a certain extent, then if somebody followed the procedure that is prescribed in terms of the old act, and a new act subsequently kicks in before it's implemented, then of course you'll be implementing a decision that was arrived at in a particular manner in terms of legislation which no longer applies. And
sorry, may I interrupt you? I don't like interrupting council, but I must take that up with you because I mean, there's no question here that everything that we're talking about here happened after 2010, which is when the amendment to the Framework Act was effected. The Katla Commission's report was finalized, it seems, in 2013. The decision, it seems, was made in 2017 or conveyed. So everything happened after 2010. I'm not going to go through all of it. So there's no question of a decision being taken under the old Framework Act. Everything happened under the amended Framework Act. So we can discard that. So the point is, how do you implement a recommendation?
By doing it with respect what the Premier said. He said, this has been recommended to me, and this is what has to be implemented. I.e., this recommendation to me, my job is now, I must now carry it forward, I must implement it by giving these notices to these parties. And we submit that is the implementation of a recommendation.
Well, let me just conclude this. I'm basically done, but it just seems to me that in the old administrative law parlance, you know, you used to get decisions which we, in old administrative law terminology, used to call mechanical. You just rubber stamp. And then you get those where you have to exercise a proper discretion. You have to assess all the documents and the evidence, if there is, before you, weigh up the pros and cons, and then make a decision. And you are the decision maker. You're exercising a true discretion. And it seems to me that the Limpopo Act envisages a mechanical rubber stamping. There's a decision taken and you must rubber stamp it. Whereas the amended Framework Act asks of you to exercise a proper discretion. You get a recommendation, you weigh it up, and then you take a decision. And you are the decision maker, not a rubber stamp. Thank you, Mr. Becker.
As you please. Thank you, Justice.
Just one aspect, Mr. Becker, on the issue that has been debated with you. I want to refer you to page 33 of volume 1, where the motivation that precedes the the signature of the Premier. On page 33, it's stated that subsequently, the Premier approved the recommendation by the Commission and informed the two groups of the royal family members about his decision. And further down under the legal implications, it is stated that the Premier agreed with the recommendations and approved that Langa Hans Malisala is the rightful leader of the Mapela community. The sense I get here is the decision was taken by the Premier.
Yes, and it may well be.
In the true sense.
We submitted that decision is the decision that we see in the Framework Act. We submit it is not a decision that would involve hearing of a party in order to, or applying OD. Yes, it is a decision like many other administrative decisions that should be taken and that are regularly taken. Not all of them involve the right for somebody to be heard and to present his case in the manner as contemplated by PAJA. And we submit that the discretion that he has in terms of the Framework Act is limited to that extent. And that is not it may be a decision, but it's not a decision which constitutes administrative action for purposes of PAJA. That's our submission on that aspect, Justice. Thank you.
Yes, Mr. Becker, do you have any further submissions to make?
I've none. I'm indebted to the court.
Thank you, Mr. Da Silva.
May it please you, I have three very short submissions. The first has to do with the interpretation of section 30. I submit that in interpreting section 30, one cannot interpret the Limpopo Act in contradiction to what the Framework Act says. We submit that it must be interpreted in the light of what Section 26(4) of the Framework Act states, and that gives the Premier a discretion. And then the second submission has to do with page 36. Justice Jafta put to my learned friend that the reference to Section 13 is incorrect, which I submit, or we submit, is correct. But we point out that the notices that the Premier published, that one finds in volume 1, the notices relieving the appellant from his position, you'll find at pages 99 to 101. Those notices refer to Section 13(3)(b), which is also incorrect. And then the final submission that we wish to make is, as I understood my learned friend, he made a submission that the decision made by the Premier is not an administrative action. I respectfully refer the Honourable Court to volume 2, page 130 at paragraph 49, where the appellant specifically stated, he said the issue and the withdrawal of a certificate of recognition is an administrative action of the nature contemplated in Section 3 of PAJA. And the fifth respondent in his answering affidavit at page 203 didn't deal with this allegation at all. In other words, it must be seen as admitted. And the first to the fourth respondent in their answering affidavit at page 282 admit the allegation. It's volume 3 at page 282 at paragraph 8.10. The deponent says, I agree that the issuing and withdrawal of a recognition certificate is an administrative action as envisaged in the Promotion of Administrative Act. So that's admitted by the first to the fourth respondent. We have no further submissions and we persist with the relief we seek in our heads of argument. May it please you.
Thank you, Mr. Da Silva. The court is adjourned and judgment is reserved.
Today's proceedings have concluded. The host will now terminate the meeting.